Okay. Testing one.
All right. Good morning, Commissioners. Good morning, everybody. We're going to go ahead and call the December meeting of the Tennessee Real Estate Commission to order. First order of business is to state the public disclaimer and the roll call. Our Executive Director, Ms. Baker, please.
Good morning. Notice of the December meeting of the Real Estate Commission, including date and time, has been noticed on the Tennessee Real Estate website since September 15th, 2023. Additionally, this month's agenda has been posted on the website since Wednesday, December 4th, 2024. Individuals who wish to make a public comment on an item listed on the posted agenda during the scheduled public comment period will need to sign in on the sign-in sheet provided or by placing their name in the chat box online. It is requested that comments be limited to 3 minutes out of respect for other speakers. I will now call the roll. Chair Diaz.
Here.
Vice Chair Ferris.
Here.
Commissioner Moffitt. Here. Commissioner Begley. Here. Commissioner Torbett.
Here.
Commissioner Gwynn.
Here.
Commissioner Smith.
Here.
Commissioner Tucker. Commissioner Gahn.
Here.
Thank you. We have a quorum.
Thank you, Ms. Baker. Next is our prayer and pledge, and leading us in both will be Commissioner Torbett. Thank you.
Sorry, bow your heads. Dear Heavenly Father, I thank you so much for the opportunity to be here today. I thank you for the safe travel and good health of everyone here. I ask that you just be with us today, give us wisdom and discernment in the decisions that we make, and help us to honor you in all we do and say. I ask that you bless everybody during this holiday season. In Jesus' name, amen.
All right. Next is the approval of the agenda. Are there any amendments or changes to the agenda? Hearing none, is there a motion?
Second.
I have a motion by Commissioner Smith to approve the agenda without amendments, seconded by Commissioner Ferris. All those in favor, please say aye.
Aye.
Any opposed? Hearing none, that passes unanimously. Next is the minutes. Commissioners, you were provided with the minutes prior to the meeting. During your review, do you notice any changes or amendments to the minutes? Hearing none, is there a motion?
Move to approve.
I have a motion to approve by Commissioner Bagley, seconded by Commissioner Torbett. All those in favor, please say aye.
Aye.
Any opposed? Hearing none, motion passes unanimously. Oh, okay. The motion was made by Commissioner Gahn.
I'll probably abstain because I wasn't here.
Okay. Commissioner Gahn and seconded by Commissioner Torbett with Commissioner Bagley abstaining. Okay. Next on the list is informal appearances. Ms. Baker, would you like to do a roll call, please?
Yes, thank you. We have 2 informal appearances today. I'll call the roll, and if those that are appearing informally, if you will please turn on your camera and your mics when I say your name. First, we have candidate A, Jacob Reppert, and principal broker Amanda Green. Jacob, are you here?
Yes, I'm present.
And your principal broker Amanda Green?
I'm here.
Very good. Next, we have Clarence E. Clan, and if I'm mispronouncing your name, I do apologize. And principal broker Hagen Stone, are you all present?
Present. Yes.
All right.
Present.
Thank you so much. We'll first begin with candidate A.
Thank you. Ms. Baker, please tell us a little bit about candidate A, please.
All right. Candidate A, Jacob Reppert, is before us today due to a theft of property, burglary, and violation of probation charges. He has taken and passed the acquisition agent exam. You will find his statement and letter of recommendation on your iPads.
Okay, so for the people appearing for informal appearances today, the way we handle these is the applicant will be allowed to state the reasons that they are appearing before us today, and there will be an opportunity for commissioners to ask questions. And then the principal broker sponsoring you will also have a chance to state why they would like to include you on their firm, and they will be also, and then another opportunity for commissioners to ask questions. Once both have been exhausted, you will then call for a vote, and the result of the vote will be what it is. After that, once you've been heard and we've been voted on, you're allowed to stay and listen to the meeting if you want, or you're free to go about your day. So go ahead, Mr. Reppert, if you go ahead and state the reasons that caused you to be before us today.
Yes, the charges that she had mentioned ranged from 2014 to 2018, I believe. I was struggling with addiction at the time. Since then, I have almost 5 years sober. I've completed an 18-month long-term inpatient treatment facility called True Purpose Ministries. I'm active in recovery now. Have consistent employment, been employed with Westgate for 1.5 years. And my hopes is to obtain the acquisition license to continue to kind of grow in my career and support my family.
Thank you, sir. Commissioners, do you have any questions for Mr. Reppert? Hearing none. Ms. Green, would you like to go ahead and tell us why would you like Mr. Reppert to be part of your firm?
I met Jake years ago before all of this happened, and he actually worked for us in the timeshare section. And I know his family, and I know his wife and his kids, and everybody goes through struggles, but he's done a lot to get through that. And so knowing what he was, how he was before and what he produced for us before, I feel that he's a great candidate for this. And everything's very observed where we work, so he won't be alone, and we're all here to support him and hope that he can expand his career with us.
Thank you, Ms. Green. Commissioners, any questions for either Mr. Reppert or Ms. Green? Hearing none, is there a motion?
Motion to approve.
I have a motion by Commissioner Gahn, seconded by Commissioner Torbett to approve this application. Any further discussion? Hearing none, let's vote. All those in favor, say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Congratulations, Mr. Reppert, and good luck.
Thank you. I
Thank
really
you.
appreciate it.
All right, next we have Mr. Elkin. Ms. Baker?
Yes, we have candidate B, Clarence Elkan, and principal broker Hagen Stone. He is before us today due to consent orders signed in Alabama as well as in Tennessee for securities. He has not taken any of the he has not taken any of the required exams for licensure. His statement and consent orders, as well as a letter of recommendation, can be found on your iPads.
Thank you. All right, Ms. Elkin, go ahead and describe the circumstances that caused you to appear before us today.
Sure. Thank you very much for the opportunity, by the way. This began almost 12 years ago. At the time, I was a financial advisor working for UBS Financial Services. Prior to working at UBS, I was at Merrill Lynch and then originally at J.C. Bradford, a total of approximately 16 years between the three firms. I had come to know a general contractor because his son and my son went to school together, and his son played on a soccer team that I coached for nearly a decade. I hired said contractor to do a very large renovation or a complete renovation on the home that I still live in today. Upon the completion of the renovation, he approached me with a business opportunity. The business plan was this. We would identify a property to be renovated together. I would finance the purchase of the property. He would handle the renovations and the financing of the renovations. Once complete, we would sell the property, take out my expenses, take out his expenses, and split the profits. Approximately, we identified a property. He and his crew got to work on it. Approximately 3 months in, he was arrested for trafficking marijuana from California to the state of Tennessee. Some of the marijuana was trafficked directly through the home that was titled in my name. It was shipped in a box. It was a bathroom vanity. Unbeknownst to me, unbeknownst to anyone else. I mean, I wasn't on site. I wasn't a crew there, and my portion was financing the home, but it was signed for. Ultimately, this contractor was arrested, charged with this, and served time. Approximately 2 months after his arrest, I was charged with money laundering, which in the finance world is a difficult charge to overcome. I took a leave of absence from UBS and I joined a small firm in Mobile, Alabama, Clearpoint Capital. My eldest brother was a principal in this firm. I have 9 older brothers and sisters. This is my oldest brother. He and I were excited about the opportunity to work together. He had done many businesses in the past, but finance was not one of them. My prior experience, as I outlined for you all, was at large wirehouse brokerage firms. And in these firms, all of your compliance and regulatory issues are all handled for you. It's all done behind the scenes with large compliance teams with really no involvement. You're kind of blind to it when you're working, which is it's the way it should be. But joining this small firm with a young compliance officer, I put the same faith in him that I had put in the prior wirehouses that I had worked with. He made several mistakes in registration, some of them in hindsight, some of them later on we learned were purposeful. He made a comment, ultimately he was released from Clearpoint Capital. When he was released, he was upset. He turned the firm into the Alabama Securities and Exchange Commission for improper licensure. We, Clearpoint, had to agree to or reached an agreement with the state of Alabama. Approximately 1 year later, I reached an agreement with the state of Tennessee as well to stop practicing securities. In the meantime, the money laundering charges were fully expunged, meaning no longer a part of my record. However, my disciplinary actions from Alabama and Tennessee are still part of my record. This is the reason that I sit in front of you all today. As noted, this all began approximately 12 years ago. I have been working gainfully employed ever since. I admittedly, several mistakes I made here in hindsight, many, but one of them was reaching an agreement too quickly with Alabama and with Tennessee because I was anxious to get on with my life and continue to support my young family. I had 3 children, still have 3 children at this time, and needed to get back to work. My wife, since all of this, has established a practice working as a realtor, and our goal is for the 2 of us to work together and me to join her and help and assist her in what she is doing.
Thank you, sir. Commissioners, any questions for this applicant? Commissioner Gwynn.
As it relates to Alabama, I noticed there's a disgorgement, which I had to look up that term, of about $300,000. How did that happen, that you had to return money to the Alabama Securities Commission?
That was the firm itself, and I was part of the firm, although not one of the principals, but that was the firm itself who returned that money to the state of Alabama. And give me a moment. I'm trying to remember right now. I believe, if I recall, it was simply a financial concession that the Alabama Securities and Exchange Commission sought. We did not, throughout all of this, I never and still have never had a client complaint. In fact, I had about 50 clients lobby and write letters on my behalf to the Tennessee Securities and Exchange Commission. I still have many of those in my possession to this day. So this agreement would have been nearly 10 years ago. And I don't think I'm remembering incorrectly. I believe it was just it was just something that the state of Alabama wanted to claim, and it was a monetary compensation that the firm itself agreed to.
So you had your Series 7 license in both states and your 63 in both states?
Yes, yeah. I had my 66 in both states and my 7 in both states. Yeah, and 66 was a combination of the 63 and the 65, if I'm remembering accurately.
So when did you give up your securities licenses? As a part of those agreements with the states?
Yes, sir, that is correct. Which I regret to this day. However, it's past tense and I can't go back, unfortunately.
Okay, thanks.
Yes, sir.
I have a question for counsel. In the order that was provided to us, it talks about, and I think I know the answer, but I want to ask anyway. It talks about him being permanently barred from being a broker or broker-dealer. So that only relates to his activities in securities, but not in real estate?
Correct.
Okay, thank you. Any further questions for the applicant? Hearing none, Mr. Stone, would you like to say anything in support?
Sure. Good morning. You can see the letter that I wrote in support of the candidate. But I just wanted to say, I, as a broker, have only written a couple of these letters in the past, and only when I felt very confident that the applicant would meet the requirements of not only TREC, but also our company and my brokerage and my reputation. So I speak fully in support of Cal's candidacy. He'll be working with his wife, who's a consistent producer in my office, and will be under my direct supervision for the foreseeable future.
Thank you, sir. Commissioners, any questions for Mr. Stone? Hearing none, is there a motion?
Move to approve.
I have a motion to approve by Commissioner Ferris, seconded by Commissioner Moffett. All those in favor, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Congratulations, sir, and good luck.
Thank you very much, everyone. Have a wonderful day today.
Thank you. Okay, now we have one waiver or two waiver requests?
We have one waiver request.
One waiver
Do you see
request.
two?
No, I don't see two.
Okay,
We got another email from Dennis. I guess that was an update.
correct.
Thank you.
We have one waiver request from Catherine Boner. Ms. Boner is seeking a waiver of fees and to reinstate her license to retired without continuing education. Ms. Boner received her initial license August 17th, 2022. She placed her license in retirement on June 29th, 2023. On April 15th, 2024, she requested to reactivate her license and requested a license certification on April 24th, 2024. Ms. Boner's license expired on August 22nd, 2024. At the date of her reinstatement application on November 26th, her fees were $275, which included the fee to renew, which is $75. Ms. Boner's license is 111 days expired. Her statement and medical explanations can be found on your iPads.
Thank you, Ms. Baker. Commissioners, any thoughts about the application? Any questions? So just the mechanics of it, Ms. Baker or counsel, we have to reinstate her license to active in order for it to be retired? Or?
That is correct.
Okay, so it has to go through that step.
And since it was active, she'll need to pay an additional $25 to retire the license.
Okay.
So it was retired, and then
She submitted an
it looks like
application.
She accidentally unretired it, basically.
That's what her statement claims. However, we have documentation that she submitted to reactivate her license.
Okay, that's what triggered the CEs and the,
Correct.
Okay.
But she was still in her first 2-year cycle.
oh, okay.
So please take note, she first got her initial license in 2022.
Right.
Question.
So she could buy a house and
Can you,
Oh,
thank you.
Didn't she activate it so she could get a referral and buy in her house in North Carolina?
That's what her statement alluded to, yes.
So if we don't agree to this, we don't waive the 200, which allows her to not pay the 200 and retire her license, what happens? If we say no, she pays the 200 to then retire her license? If she doesn't pay it, what does she do?
She would pay the civil penalty of $50 a month per 30-day period up to 120 days. So that's $200 because she's 111 days expired. Then
Okay.
she would also need to pay the $75 to renew her license and then additional $25 to retire her license.
But if she says, I can't pay, so she keeps racking up $50 a month or whatever the number is
Yes.
indefinitely until.
Up to a year.
Up to a year.
And then after a year, she can retest and reapply.
But she doesn't want to keep her license going, right?
According to her letter, she wants to retire her license in Tennessee.
So if we let her retire the license and she wants to bring it back out, does she have to take some CE and stuff to get it back out?
Correct.
I'll make a motion.
Commissioner Gwynn, go ahead.
I move that we reduce the 200 to 100, and that's it.
In addition to the renewal fee?
Yeah, how much is the renewal fee? 50?
$75 every 2 years.
And she's not asking to waive that, right?
Well, she does say that she can't pay any additional fees, so I guess in her ideal scenario, she wouldn't have to pay anything, but
But she's trying not to pay anything to retire a license. She's trying to get out of the business, it sounds to me like.
she looks like, it seems to me, she's trying to keep her, keep her options open. If she, because if her medical situation changes, she might decide that she wants to come back into the business and she wants a license there, so she doesn't have to retest and reapply, just do some CE and go back into the business. I can see why she would want that. The question is, she can't pay the fees right now. And her license is in expired status right now?
Her license is in expired status,
And
yes.
she was, she's, what, 5 months in now? 4 months? in?
111 days.
111 days, so she's about to get bumped up to the next.
Correct.
I'm still confused. So she successfully retired the license?
Yes.
Paid whatever it was
She paid the
retired,
$25,
and retired it.
June 29th, 2023. She retired her license. On April 15th, 2024, this year, she got her license out of retirement.
Apparently chased down some referral situation in North Carolina.
According to her statement, she wanted to be a referral agent.
Okay.
This is,
So I have a motion from Commissioner
good.
Gwynn.
Yes, yes.
You want to clarify your fee? You want to reduce to 100. What do you want to do with the active reactivation fee?
saying, keep it as is.
So 175.
175.
fee total?
Yeah, instead of
And
275.
Instead of 275. So his motion is to assess a fee of $175 and allow her to reactivate and retire the license.
I want to make sure I understand you correctly. The civil penalty is $100 and then the renewal fee of $75 is.
Right.
Thank you.
And no CE.
Correct.
And, I mean, it sounds like to me she's not trying to become a referral agent.
Hold on. Is there a second for that motion? Second. Okay, I got Commissioner Gwynn's motion, a second by Commissioner Moffitt. Go ahead, Commissioner Ferris.
Thank you, Chairman. It doesn't appear to me in her letter that she is attempting to be a referral agent. Like, this looks like it was just a one-off for her own purchase of a home in New Hampshire. Are y'all reading that right? Are y'all reading the same way, or am I?
Yeah.
So I don't think it's any one of us may do any one of many things down the road. So she might try to get back in the business. It doesn't seem that that's the case here. I would have been probably more in line to just approve her request, but I'm open to hearing more thoughts.
Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion, say aye.
Aye.
Any opposed?
No.
Oh,
I will request a roll call vote.
Thank you.
By Executive Baker. Ms. Baker, when you're ready.
all right. Chair Diaz,
No.
Vice Chair Ferris,
No.
Commissioner Moffitt,
Yes.
Commissioner Begley,
No.
Commissioner Torbett,
No.
Commissioner Gwynn,
Yes.
Commissioner Smith?
Yes.
Commissioner Gahn? The noes have it.
What is it, 5-4?
Yes, 5-3.
5-3.
Yes.
Motion fails by a vote of 5-3. The floor is open for another motion.
I'll make a motion to approve the request.
Second.
What do you want to do about the $75 fee?
I mean, there's nothing in the request to waive it. Can we waive that?
We have the discretion. We do.
That is a question for council.
Okay,
Everyone
council.
else in the state pays the $75 renewal fee. I'm not sure why.
I mean, she didn't ask to have that waived. Maybe she doesn't know about it, but I'm happy to leave that in there. I'm just accepting her request as
To
written.
waive the $200
And the CE.
and the CE. Okay.
All right, so Commissioner Torbett makes a motion to waive the $200 fee and the CE requirements, and that was seconded by Commissioner Bagley. Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, it sounds like that passes on a 7 aye, 1 no vote, with Commissioner Gwynn voting no.
Thank you.
So, Ms. Baker, are you going to do our education report for this month?
I am.
Okay.
Thank you. I'm pleased. We're gonna begin with the introduction of the new Director of Education, Ms. Brittany Morris. I'm pleased to introduce her as the new Director of Education. Brittany began with TREC on December 2nd and is currently being trained on internal processes and all things TREC as well as TDCI. I would love for her to come up for a moment and introduce herself to you all.
Thank you, Commissioners and Director Baker, for allowing me to speak today. I'm very excited to be here and be part of this wonderful team. To give you a little background on myself, I have a bachelor's in biology and a master's in public administration. Previously, I was at the Tennessee Department of Transportation's Highway Beautification Office, where I served in several roles, my last being the Transportation Program Supervisor for the office. In my nearly 7 years at TDOT, I helped educate Tennesseans of all ages about the harmful effects of litter, as well as train and educate county officials on education best practices and grant spending. Prior to my role at TDOT, I was a student services coordinator with the Colorado State University Pueblo, where I assisted non-traditional military students in obtaining their bachelor degrees while serving our country. I am excited to use my nearly 10 years of knowledge in program management and adult education to assist Director Baker in making Tennessee's Real Estate Commission the best in the nation. And I am looking forward to giving you my first report at the commission meeting in February of 2025. Thank you so much.
Thank you so much, Brittany, and on behalf of all the commissioners, welcome. Thank you. Ms. Baker, what do you got for us in terms of courses this month?
All right. You have on your iPads 37 courses that I submit for your approval. We added an additional course. If you look at course 6, that was added this week for your approval as well.
Commissioners, is there anybody that wants to pull a course for further discussion? Courses D1 through D37. Hearing none, is there a motion?
Second.
Commissioner Smith makes a motion to approve the education report, seconded by Commissioner Ferris. Without further discussion, is there all those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. By my count, Ms. Baker, you got 11 instructors for us. Is there more?
Yes, I submit to you all 11 instructors for approval. We have reviewed their credentials and present them to you all for approval today.
Now, is this the high volume that we expected because of the renewal cycle with these?
Yes.
Okay.
Yes.
There's 11, that's a lot for,
Yes.
even in my time here, that's a big number. Okay.
We
Commissioners,
got
any?
the word out that we won't have another meeting until February, so I think
Okay.
everyone is rushing to
Good.
submit
Okay.
everything they needed to submit to teach in January.
Commissioners, any questions about any of these applicants for teaching or an instructor's license? Hearing none, if there's a motion.
Second.
I have a motion to approve these instructors by Commissioner Gwynn, seconded by Commissioner Ferris. All those in favor of the motion, please say aye. Aye. Hearing none, All those opposed? Hearing none, that motion carries unanimously. Thank you so much, Ms. Baker. Anything else for the education report?
I just want to let you know that we've approved hundreds of renewals for instructors as well as courses. I just want to thank Scott for assisting me and getting those organized in a manner in which that we can approve them internally. Since they are renewals, they don't have to come before you all. So I just want to thank Scott for his efforts doing that in the absence of a director of education.
Okay. The second part of your duties, the executive director report,
Yes.
please, Ms. Baker.
Yes, I have a few announcements and updates for you all. If you look on your iPad, you'll see my report that shows the active license by profession as well as the exams taken and the open and closed reports. Commissioner Gwynn, I know you are looking for an updated report, and we hope to have that for you in February as far as our open and closed complaints report is concerned. If there are no questions about that portion, I have a few updates for you all. Are there
Please
any
proceed.
Thank you. You will find on your iPads, you will see the formal invitation from Tennessee Realtors to participate on a panel discussion for the 2025 Tennessee Excel Summit on Tuesday, February 11th at 2 o'clock. Please note, we do anticipate a hearing on February 12th, and we'll have additional details in reference to that in January. Will everyone be able to participate? Commissioner Moffitt, I know you will be out in February. But will everyone else be willing to participate in the panel discussion? Very good. Thank you. Next, Arello's mid-year meetings will take place in San Diego, California, April 14th through 16th. The day after the mid-year meetings conclude, Arello will present Commissioners College 102. If there are any TREC commissioners that would like to attend the mid-year meeting or Commissioners College 102, please let me know. We'll be finalizing plans to attend in early January.
What are those dates again? April
14th through 16th, and Commissioners College is April 17th. Commissioners College 102, so it's a different course from the 101 course. Next, I have an update on public records request. TREC has seen an influx of public records requests that requires reconfiguring data points within our system. Beginning in January 2025, TREC will be requesting reimbursement for some public records requests when costs are incurred for design, development, testing, implementation, and training required by the requester. This is in line with TCA 10-7-506. Are there any questions in reference to public records request?
Any guesses as to why we're getting the increase? What kind of records are they looking for?
All sorts of things. I would assume they were for promotional purposes, but
So not a pattern or a theme that you see yet? Okay, thank you.
I have an update on E&O insurance. As of Sunday, December 8th, TREC has had 9,527 licensees signed up for the Rice E&O insurance. This number is consistent with what Rice saw during the 2021 and 2023 enrollment periods. The last few weeks of December are where Rice historically sees the majority of enrollments. We expect the enrollment numbers to pick up significantly. Rice has an email blast going out this week to those who have yet to enroll, reminding them to enroll. We have a dedicated staff person, which is Amy, who is dedicated to working those E&O insurance rosters this month, and she's constantly updating our systems to make sure that everyone is in compliance that has paid for their 18th month term with Rice Insurance. Are there any questions in reference to insurance, E&O insurance? I have one last update, and this is in reference to TREC's team. TREC has had quite the year. this year. We've seen promotions, retirements, professional certifications, leadership programs, stretch assignments with the first of its kind high school graduate licensure program. We even have a new U.S. citizen. From January 1st through December 7th of this year, we have answered 49,880 voice and non-voice tickets. We revived TREC's audit program and have completed over 108 audits. We've also processed over 29,000 initial applications, renewal applications, and transfer applications. I'm pleased to be here with TREC team members today. With the help of this team, a customer service center, a complaints office, our legal department, and a host of others within TDCI, they ensure that real estate licensees in Tennessee receive the best customer service and that consumers have the resources when needed. TREC's mission is protecting Tennesseans and empowering professionals. I am honored to be doing that work alongside the dedicated team members of TREC and within TDCI that approach their jobs with grace and professionalism to ensure our mission is met. And if all the team members of TREC would please stand up for a moment, I would greatly appreciate it. If there are no other questions, that concludes my report.
Okay. And just again, on behalf of all the commissioners, thank you, everybody, for everything you do throughout the year and that you've been doing. Thank you so much. So next on the agenda is public comment. Has anybody signed up to address the commission?
No, we don't have anyone signed up in the chat or in the room that has signed up for public comment.
Okay. That being said, I will close the public comment period. Do we want to push through to the rulemaking, or do we want to?
We do.
Okay, let's go ahead and do the rulemaking. Ms. Matlock.
This rulemaking hearing is called to order. My name is Anna Matlock. I serve as an Associate General Counsel in the Department of Commerce and Insurance, Division of Regulatory Boards, and I represent the Tennessee Real Estate Commission. Would the agency representatives who are present introduce themselves for the record?
My name is Denise Beard. I'm the Executive Director of the Tennessee Real Estate Commission. My name is Denise Beard Baker. I just used my maiden name. I don't know why I did that. And it's on the record, and the stenographer is here. Wonderful. My husband will be so pleased. I'm sorry, Matthew. If you all would introduce yourselves, please.
Steve Gwynn.
John Murphy.
Joan Smith.
DJ Ferris.
Jeffrey Diaz.
Stacy Torbett.
Joe Begley.
Mike Gahn.
Thank you. Today is Wednesday, December 11th, 2024. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204 in Conference Room 1A, Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. And also available by electronic means via Microsoft Teams, which can be located on the program's website, www.tn.gov/regboard/trec/meetings.html. On this page, the link for access to this rulemaking hearing via Microsoft Teams can be found in the chart located in the middle of the web page in the row with the date 12/11/2024 in the location column under the words Davy Crockett Tower, Room 1A, 500 James Robertson Parkway, Nashville, Tennessee 37243, labeled Register to Attend. The purpose of this rulemaking hearing is to solicit comments on rule amendments to the rules and regulations of the Tennessee Real Estate Commission. The proposed rules amend certain general licensing rules of conduct and vacation lodging service requirements resulting from the department's review as required by the General Assembly's enactment of Tennessee Code Annotated Section 4-5-213. Most of the rule amendments are clerical and do not impose any additional licensure standards. Specifically, the rule amendments simplify civil penalty schedules, lower the barrier of entry for certain individuals with criminal convictions, clarify the errors and omissions insurance and gifts and prizes reporting requirements, and repeal an outdated rule related to telephone answering services. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, then end of which time will be the effective date. Please listen carefully. Those members of the public wishing to speak and appearing in person should place their name on the sign-in sheet on the podium to my right. Those members of the public wishing to speak and appearing via Microsoft Teams should put their name in the chat box. Oral comments will only be accepted by those who have written their name on the sign-in sheet and typed their name in the chat box. Is there anyone that desires to offer oral comments but has not written their name on the sign-in sheet or typed their name in the chat box? Seeing that there are none, for those attending this hearing in person, I would call your attention to the podium to my right again. On this podium, you will find red-line copies of the rule amendments addressed in today's rulemaking hearing. For those attending on Microsoft Teams, you will find a link in the chat box to the red-line copies of the rule amendments for today's rulemaking hearing. The notice of rulemaking hearings include the entire text of the proposed rules and were published on the Tennessee Administrative Register website on October 2nd, 2024. Ms. Baker, what additional notice was given to the affected individuals or groups?
Information for the time and location of the hearing was placed on the program's website. An e-notify was sent to all licensees signed up for the program system on October 8th, 2024. Lastly, the program provided notice in TREC's newsletter emailed to licensees on November 4th, 2024.
As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. I will summarize the substance of the proposed rules into the record. Rule 1260-01-.01, Applications for Examination. Paragraph 4 is amended by deleting the text of the paragraph in its entirety, and paragraph 6 is amended by adding a new subparagraph D. Rule 1260-01-.15, Errors and Emissions Insurance Coverage, is amended by adding a new paragraph 5. Rule 1260-01-.16, Lapsed Errors and Emissions Insurance, paragraph 1, subparagraph A, part 1, is amended by adding a new subparagraph 3. Rule 1260-01-.16, Lapsed Errors and Emissions Insurance, paragraph 2, subparagraph C, part 1, is amended by adding a new subpart 3. Rule 1260-01-.19, Appearances before the Commission for the purposes of obtaining a license, is amended by deleting the text in its entirety and substituting new language. Rule 1260-02-.01, Supervision of Affiliate Brokers, paragraph 1 is amended by deleting the word his and substituting their. Rule 1260-02-.02, Termination of Affiliation, paragraph 1 is amended by deleting the text faxed and or, as well as adding the language or submitted on a form designated by the Commission. Rule 1260-02-.02, Termination of Affiliation, paragraph 2 is amended by adding the language, failure to comply with this provision may result in the imposition of disciplinary action. Rule 1260-02-.02, Termination of Affiliation, paragraph 6 is amended by deleting the word notarized and substituting the word an. Rule 1260-02-.10, Closing Statements, is amended by deleting the word he and substituting instead they. Rule 1260-02-.32, Civil Penalties, paragraph 1, is amended by deleting the text in its entirety and substituting language instead. 1260-02-.32, Civil Penalties, paragraph 2, is amended by deleting the text in its entirety and substituting language, new language. 1260-02-.38, death or extended absence of principal broker, is amended by adding a new paragraph 4. 1260-02-.04, telephone answering services, is repealed in its entirety. Rule 1260-02-.34, interpleader form, is repealed in its entirety. Rule 1260-07-.04, civil penalties, paragraph 1, is amended by deleting the text of the paragraph in its entirety and substituting language instead. Additionally, the Commission proposes several amendments to Rule 1260-02-.33 by adding a new paragraph 2, which states, 2, a licensee shall not give or pay cash rebates, cash gifts, gift cards, cash prizes, or any similar cash-based incentive in conjunction with the real estate transaction, except for the following circumstances. A licensee may offer a gift card and an open house for other real estate licensees. B, a licensee may offer a gift card as a closing gift. And C, the gift cards in subparagraph B may not be used in any advertisement to induce business in conjunction with a real estate transaction. Ms. Baker, were any written comments received by the Commission Office for the rule amendments that were not forwarded to me prior to today's hearing?
No.
I will now read the written comments I received via email prior to this hearing. The first comment is from the Memphis Area Association of Realtors. Comment. Dear Ms. Matlock, I am writing on behalf of the Memphis Area Association of Realtors to provide comments on the proposed amendments to Rule 1260-02-.33 regarding gifts and prizes. Specifically, we strongly object to the inclusion of gift cards with the list of prohibited items in paragraph 2. While we recognize the rule's intent to prevent undisclosed payments that might influence real estate transactions, we believe the blanket prohibition of gift cards is overly restrictive and fails to account for legitimate business practices. Gift cards are a standard tool in customer appreciation and marketing across many industries. Their use in the real estate marketing, such as at open house events, is a customary practice that enhances engagement without compromising transaction integrity. Gift cards in small denominations serve as tokens of appreciation, not significant financial incentives. They are often employed to resolve minor issues near closing, such as addressing incomplete repairs or misplaced items, ensuring smooth closings for all parties. Additionally, consumers can always decline a gift card if they feel it could influence their decisions, preserving their autonomy in the transaction process. Finally, small gestures like gift cards can address minor disputes outside of closing, preventing delays and reducing potential legal conflicts over minor disagreements. We recommend the rule be amended to exclude gift cards from the prohibited items in paragraph 2. Alternatively, the rule could permit non-transferable gift cards or store credits that are not exchangeable for cash. Such a provision would safeguard against unethical practices while allowing licensees to continue legitimate practical use of gift cards. The prohibition of gift cards under Rule 1260-02-.33 imposes unnecessary restrictions and undermines practical business operations. We urge the Tennessee Real Estate Commission to reconsider this provision and adopt a more balanced approach that addresses consumer protection while supporting reasonable business practices. Thank you for your attention and consideration of these comments. We welcome the opportunity to discuss this matter further. Sincerely, Scott Bettis, 2024 President, Memphis Area Association of Realtors. I will add that following receipt of this comment, I did reach out to the Memphis Association of Realtors to inform them of the edits that we were making to the gift card rules, and following that, requested if they still wanted to submit their comment, and they still stated that they did. So that is that information had been submitted to them prior to this meeting. So now I will ask if is there any comment from the commission?
Commissioners, any thoughts on the comments submitted by the Memphis Area Association of Realtors?
Do you feel that 2B adequately addresses their concerns?
I do think that the new addition of the new paragraph that includes that gift cards can be used at open houses and as closing gifts would address their concern. However, it appears that they wish that gift cards to not be included at all. So I don't know if it answers that question completely.
So the suggestion, if I heard you correct, was not necessarily gift cards, but store credits. Did I hear that comment?
Correct. It mentioned that alternatively, it states alternatively, the rule could permit non-transferable gift cards or store credits that are not exchangeable for cash.
So they're basically asking, should we say a licensee may offer a gift card or store credit? They're asking for that language to be added. Is that what I'm hearing?
It's asking if non-transferable gift cards can be permitted or store credits. So essentially, it would, to my understanding, possibly change the rule to transferable gift cards instead of just gift cards. Store credits is not included in the rule or the amendments. Therefore, I don't believe that it would be susceptible to this provision.
So, and then the real question is from an enforcement perspective.
Correct.
The only way that anything like this will come before the commission is if a complaint is filed.
That's correct.
And the circumstances of what this gift card, the construction of any gift card becomes a question.
Correct.
So we would then have to dive into, okay, how is that gift card purchased? Who's the vendor? How is it redeemed? All that kind of stuff.
Not necessarily. I think with the rule as it is written right now, if it's a gift card and it's not used in a broker open house or as a closing gift, despite how it was given to that person, it would not be permitted.
Okay.
However, from the comment, it seems like that's already happening anyway, which I did clarify as well. So, to clarify at this point, gift cards are not permitted and has been the Commission's standpoint for a while. This rule is being amended to provide clarification that has been sought by several entities related to gift cards. So it is a provision in the statute that was brought into rule. However, it provides the clarification that the Commission does consider gift cards to be the same as cash. And so it would only permit gift cards to be used in the two instances that we discussed at the November meeting, which would be at a broker open house for licensees or related to a closing gift.
My thought about their letter is well received, well taken, and I'm thankful they submitted it. And I'm thinking it'll be challenging to prove what's a closing gift and what is a gift card used to smooth a transaction over, as they referenced in their letter. If there's a transaction nearing closing, there's a wrinkle that needs to be smoothed out, or the parties need to try to find an agreement with regards to repairs or whatever, for there to be a closing gift, for there to be a gift card given by a listing broker or a selling broker, and both of the parties to sign off on it as a closing gift, it's hard to dispute that if all the parties are in agreement. Because I could see a listing broker or a buyer broker saying, here's a closing gift of $100 gift card to Home Depot. Mm-hmm. And for the buyers or the seller to have a moment to agree to that, I mean, that does happen, and that doesn't seem out of line in my opinion.
Right. So if it's used as a closing gift, that wouldn't be an issue.
Right.
And my interpretation of a closing gift would be to the parties of the transaction.
Right.
So if we're giving gift cards to other individuals that are related to it, I don't know, home inspector or an appraiser or something, that would not be considered a closing gift because
Yeah,
they're
and
not party to the contract.
I don't know anybody who does that.
Right, I'm just
Right, I
saying,
know,
you
I'm
know,
just- yeah, we're-
it's stated to
yeah.
smooth over transactions, right?
Right.
So that's the only, I don't know what that context means. No additional context was provided if they're if they're given to other individuals outside of the parties of the contract.
Yeah.
So, and I think in our conversation in November and earlier conversations, I was concerned about gift cards being used as an inducement to sign a client. And as long as, again, the transaction, they're already clients or you're closing a transaction, that relationship has been established independent of the gift cards being given. Then, as long as it's to the parties of the transaction, the buyer, the seller, then I think they're good there under this rule as it is.
Right, so it states, you know, that gift cards may not be used as an inducement to a transaction. So that would not be permitted. The gift cards are only used for those two specific instances of closing gift and at broker open houses.
And, you know, and two other comments. I think we discussed and I rejected the idea of limiting dollar value.
Correct.
I think that was hard to police. I thought it may be.
Yes.
And then I think there are letters stating, well, the consumer can always refuse the gift card. That's laughable in my perspective. I don't think anybody's going to refuse a gift card.
I mean, I don't like Captain D's, so I would say no if it was to there, but otherwise, yeah, I don't see the same
But
thing.
for the most part, I just think that, you know, yeah, they could refuse it. I think 99 times out of 100 they won't. It's like, ooh, gift card, you know, and so I think there's plenty of room in the rule as it's amended right now for what has become typical business practice to allow our brokers to continue to offer gift cards of some value to smooth over transactions or offer them as closing gifts. That's just my opinion. Anybody else?
I would agree. I mean, did MAR offer any alternative language? I mean, what do they want to do with number 2? Do they want to scrap it all, or they want to tweak it, or did they say, or?
I'll just reread what it said. We recommend the rule to be amended to exclude gift cards from the prohibited items. Alternatively, the rule could permit non-transferable gift cards or store credits that are not exchangeable for cash. That's the only thing that was provided in the comment.
In the first sentence there, then they want to take out the words gift cards, and that's basically it?
Correct.
Well, it seems to be
But it seems like A, B, and C allows them to do what they want.
I would think it would be
I
further
did
amended.
explain that to the parties via email, and they still wished for their comment to be heard at the hearing today.
Yeah, and I think, again, all of this, anybody being called before the commission under this rule requires a complaint first. So I don't see people complaining about gift cards all that much.
Correct. We have not had a gift card complaint several years.
So for me, in order for it to get a complaint, it would almost have to be a pattern of behavior and egregious for another broker or another consumer to say, this is ridiculous and unfair.
Correct. We're not policing gift cards. There are no inspections for gift cards.
Yeah.
So it is really honestly just for clarification purposes.
Or it's an obvious inducement prior to a agency relationship being established.
That is correct.
Okay. Any other comments, commissioners? Otherwise, I will entertain a motion. Are we ready for motion?
Oh, no, not yet.
Questions or comments? Ms. Matlock, please continue.
I will now solicit comments from individuals present at today's meeting, either in person or via Microsoft Teams.
Are there any public comments? If so, please come forward.
Yeah, I'd welcome any of the practitioners or the licensees in the audience. If y'all would like to have your time in in the, on the record here. Please step forward. And, you know, you guys are the ones practicing this along with me and several of my colleagues here, so.
We have no public comments.
Hey, had your chance. Yeah.
Seeing that there are none, this concludes the comment period for this rulemaking package. Lastly, there are several measures that will need to read into the record as required by TCA Section 4-5-222. All voting will be conducted by roll call. First, I will need a motion to adopt the hearing rule language as provided.
Is there a motion to adopt the hearing rule? I have a motion by Commissioner Gwynn to adopt a hearing rule. Is there a second? Seconded by Commissioner Smith. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously.
I apologize. We'll have to retake the vote as all votes have to be made by roll call.
Ms. Baker, when you're ready.
Thank you. Chair Diaz,
Yes?
Vice Chair Ferris,
Yes.
Commissioner Moffitt,
Yes.
Commissioner Begley, Commissioner Torbett,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Smith,
Yes.
Commissioner Gahn.
Yes.
Thank you.
Next, I will read the regulatory flexibility addendum pursuant to TCA sections 4-5-401 through 4-5404. Prior to initiating the rulemaking process, all agencies shall conduct a review of whether a proposed rule or rule affects small businesses. Prompt 1, the type or types of small businesses and an identification and estimate of the number of small businesses subject to the rule being proposed that would bear the cost of or directly benefit from the rule being proposed. Answer 1. The Commission does not foresee small businesses bearing significant costs to comply with the rule amendments. While some of the Commission's licensees are small businesses, these rule amendments will apply equally. As the amendments impose no new license requirements, a cost of compliance, if any, will be minimal. Prompt 2. The projected reporting, record keeping, and other administrative costs required for compliance with the rule being proposed, including type of professional skills necessary for preparation of the report or record. Answer 2, the Commission does not foresee a cost for the administration and enforcement of these rules. Prompt 3, a statement of the probable effect of impacted small businesses and consumers. Answer 3, the Commission does not foresee a significant impact on small businesses with these rule amendments. While some licensees are small businesses, these rule amendments apply to all licensees within the industry equally. Prompt 4, a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the rule being proposed that may exist, and to what extent the alternative might be less burdensome to small business. Answer 4, the Commission knows of no other less restrictive or burdensome means than through the promulgation of these rules as amended. Prompt 5, a comparison of the rule being proposed with any federal or state counterparts. And answer 5, rules and regulations for the real estate industry vary across the country. However, the rule amendments may be like current or proposed rules and regulations in other state-level regulating jurisdictions. The Commission is unaware of any similar existing proposed federal rules. Prompt 6, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the rule being proposed. Answer 6, the Commission does not foresee the need for a possible small business exemption of the requirements in the proposed rules. The rule amendments apply equally to all real estate licensees in the industry regardless of size of their business. Therefore, the Commission does not see a disparate impact to small businesses. Additionally, the rule amendments provide many clerical updates for simplicity and ease, which may assess small business in their daily practices. Therefore, an exemption for small businesses would not be beneficial. I will now need a motion to adopt the regulatory flexibility addendum.
Is there a motion to adopt the regulatory flexibility addendum?
So moved.
Motion was moved by Commissioner Gahn, seconded by Commissioner Bagley. The vote will be by roll call. Ms. Baker, when you're ready.
Thank you. Chair Diaz,
Yes?
Vice Chair Ferris,
Yes.
Commissioner Moffett,
Yes.
Commissioner Begley,
Yes.
Commissioner Torbett,
Yes.
Commissioner Gwynn,
Yes.
Commissioner Smith,
Yes.
and Commissioner Gahn.
Yes.
Thank you.
I will now read the impact on local government statement pursuant to TCA Section 4-5-228. The Tennessee Real Estate Commission foresees no impact on any local governments. I will now need a motion to adopt the impact on local government statement.
Is there a motion to adopt the impact on local government statement?
So move.
The motion has been moved by Commissioner Smith, seconded by Commissioner Moffett. The vote will be by roll call vote. Ms. Baker?
Thank you. Chair Diaz,
Yes?
Vice Chair Ferris, Commissioner Moffett,
Yes.
Commissioner Begley,
Yes.
Commissioner Torbett,
Yes.
Commissioner Gwynn, Commissioner Smith,
Yes.
and Commissioner Gahn.
Yes.
Thank you.
I will now read the answers to the questions required by the Joint Government Operations Committee. All agencies, upon filing a rule, must also submit the following pursuant to TCA Section 4-5-226I1. A brief summary of the rule and a description of all relevant changes and previous regulations effectuated by such rule. Response: the proposed rules amend certain general licensing, rules of conduct, and vacation lodging service requirements resulting from the Department's review as required by the General Assembly's enactment of Tennessee Code Annotated Section 4-5-213. Most of the rule amendments are clerical and do not impose any additional licensure standards. Specifically, the rule amendments simplify civil penalty schedules, lower the barrier of entry for certain individuals with criminal convictions, clarify the errors on emissions, insurance, and gifts and prizes reporting requirements, and repeal an outdated rule related to telephone answering services. B, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or established guidelines relevant thereto. Response: there are no known federal or state laws or regulations mandating the promulgation of these amendments. C, identifications of persons, organizations, corporations, or governmental entities most directly affected by this rule, and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of this rule. Response: the rule amendments affect current and future licensees as well as applicants. The Commission anticipates proponents of the rule amendments to include current and future licensees, as the amendments positively impact those within the industry. As most of the rule amendments are clerical in nature, the Commission does not foresee a segment of opponents to the amendments. D, identification of any opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. Response: there are no known opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. E, an estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state that the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. Response: there is no foreseeable probable increase or decrease in state and local government revenues and expenditures. F, identification of the appropriate agency representative or representatives possessing substantial knowledge and understanding of the rule. Response: Anna D. Matlock, Associate General Counsel for the Tennessee Real Estate Commission. Denise Baker, Executive Director for the Tennessee Real Estate Commission. G, identification of the appropriate agency representative who will explain the rule at a scheduled meeting of the committees. Response: Anna Matlock and Denise Baker. H, office address, telephone number, and email address of the agency representative or representatives who will explain the rule at a scheduled meeting of the committees. Response: the contact information for Anna Matlock and Denise Baker are listed. I, any additional information relevant to the rule proposed for the continuation the committee requests. A response: not applicable. I will now need a motion to adopt the additional information for the Joint Government Operations Committee.
Is there an amendment to adopt the Joint Government Operations Committee report? I have a motion's been made by Commissioner Smith, seconded by Commissioner Moffitt. The vote will be by roll call. Ms. Baker?
Chair Diaz,
Yes.
Vice Chair Ferris,
Yes.
Commissioner Moffitt,
Yes.
Commissioner Begley,
Yes.
Commissioner Torbett,
Yes.
Commissioner Gwynn,
Yes.
and Commissioner Smith,
Yes.
and Commissioner Gahn.
Yes.
Thank you.
That concludes this rulemaking hearing. Following the hearing, the rules will be held for additional, put on a rulemaking filing form, SS 7039, submitted to the governor's office for final review, and then submitted to the attorney general's office for review and approval. Once the attorney general's signature is obtained, these rules are filed with the Secretary of State and generally become effective 90 days from the date of filing after receiving a positive recommendation from the Joint Government Operations Committee. Thank you for being here today.
So that finishes the rulemaking, Ms. Baker. Thank you very much. All right, so we are going to go ahead and go into recess. We will recess for 10 minutes, reconvening at 9:50. We are in recess. Thank you, everybody. We're going to come back into order, please. We're going to resume our agenda here with the next item of business, which is going to be the legal and consent report. There's a number of cases that have been pulled, but first I wanted to verify with council. They have labeled a number of cases for discussion, and I have cases 25 and 55. I wanted to make sure there weren't others to be pulled, if you know. 48. Just looking for discussion. Cases that have been pulled to discuss by council.
Also 32 and 48.
32 and 48. Okay, thank you. Thank you, Steve. Okay, so the legal and consent agenda. Commissioners are provided with narratives for the cases that are going to be considered at this month's meeting, and commissioners have the opportunity to read those cases and pull cases for further discussion. Of those cases, commissioners requested to pull the following: cases 3, 12, 19, 20, 24, 25, 27, 28, 32, and 48, with case 25, 55, 32, and 48 being pulled for discuss by the commission.
So add 55 to that list.
25, 32, 55, and 48, council asked us to discuss. They have not yet given a recommendation. Are there any other cases commissioners wish to pull? Hearing none, is there a motion to accept council's recommendation for the cases being considered today, minus those read into the record?
So moved.
Second.
I have a motion by Commissioner Smith, seconded by Commissioner Torbett, to accept council's recommendations on the cases submitted for the December report, minus those cases that were read into the record. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. The first case up is case number 3, and that's me.
Chair Diaz, before you proceed,
Ma'am.
can you repeat who made and seconded the motion?
The motion was made by Commissioner Smith, seconded by Commissioner Torbett.
Thank you.
Case number 3, that was pulled by me. All right, so we're going to consider case number 3. I pulled that one. My concern with this one is that the respondent kind of had this case fall into their lap a little bit. They weren't the original listing agent. They weren't, just kind of landed on them. And there was a mutual release after 3 days, so it didn't seem like there was an extended period of time. I just don't know what else the respondent was supposed to do to handle the relationship. I mean, it was a fully mutual release part of the record. Do you have that?
I do have the mutual release from both parties. My concern was that there were some emails back and forth, before the property, with the property owner and the respondent. And most concerning of all is that the property owner, as I put in the report, was surprised to look up their own listing and see that this respondent was now in charge of their listing, which is why I recommended what I did.
All right, so the handoff wasn't communicated well?
Correct.
Council's recommendation was a $1,000 civil penalty for failure to exercise reasonable skill and care. Anybody else has questions about this case? If not, there's a motion.
So in our MLS, if an agent leaves my office, all those listings go into my name that agent has until they're released either to that agent or done something else with. So I can see where that would happen. And it sounded like he was out of town that weekend, and the listings got put into the broker's name, and he somewhat rectified it first of the next week, it sounds like. Am I wrong with that?
My understanding was that the principal broker whose listings they fell to is not the respondent. It's a principal broker of a related firm, that because the principal broker of that firm was out of town, said, well, I'll become the, so it seems like there was a breakdown in communication as to who was going to respond and how quickly. And again, that the seller here was the one who was kind of left looking around saying, what's going on? Who is handling my listing?
I mean, I kind of sympathize with this respondent a little bit.
Yeah, I do too.
It's kind of like, I inherited this thing. I wasn't responsible for communicating. I mean, maybe, I guess when you got the listing, you should have reached out to the seller or the client and introduced themselves, but I don't know. Floor's open for a motion.
Yeah, I sympathize with them too. I think you and Mike both have made good points. Joan, what do you think?
I'm curious, what kind of two firms are operating out of the same physical address? Are they both real estate companies or one of them a management company?
I believe it was 2 firms.
I mean, for this respondent, for this case, I mean, I letter
It was
of.
just a curious question.
I know.
It
I
was just-
think for a letter of warning or a letter of instruction would probably be, just say, remind him to exercise reasonable skill and care, and when you inherit a listing, make sure you reach out to the seller quickly.
But he's saying he didn't know he had inherited the listing, correct? I'm skim reading this one because it's not one I pulled.
The principal broker of the firm of the affiliate that was released inherited the listing. It responded is in a related firm, is how I took what they were saying. And because the principal broker of that firm was going to be out of town and therefore unable to communicate, this respondent stepped up and said, well, I'll handle it while you're gone.
Okay.
In the interim, when the sellers found out that their agent had been released, they asked to be released from the right to sell, and they
Sure.
agreed, so.
So my question is, on the listing agreement, what, of course, you can't give me the name of the firm, but was the name of the firm on the listing agreement ABC, and this respondent also worked for ABC, or was it ABC and this respondent worked for BCD or something? Were they the same company? I mean, when they saw the listing and were surprised, was it with a different firm or just a different agent, broker?
It was.
Or SOL.
There was the umbrella firm, and then there were two different offices, and it was, it was the same firm name, and they had multiple offices.
Well, I can see how they would be surprised, because I think the general public may think when they list a property, it's with that agent that's sitting with them at the dining room table, but the firm actually owns the listing. So I think this person was in the right, and to sell it within 3 days by, the person saying, hey, I want to be with Joe, and he's gone, and you release everything in 3 days, I don't think there's anything you did wrong here.
You wanna make a motion, Joe?
I'll make a motion to dismiss.
I have a motion to dismiss this case number 3 by Commissioner
Second.
Bagley. Is there a second?
Second.
Seconded by Commissioner Gahn. Is there any further discussion? Hearing none, let's vote. All those in favor of the motion in case number 3, say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 12. That's me also. Okay.
Speaking of gift cards.
I did. No, ma'am, I'm not. Just, again, the narrative, very, very small, these narratives. So in my notes, I asked about,
Let me break in for a second.
Go ahead.
Chairman, are you asking me to be more long-winded in my?
no, it's just, it's notable when the narrative is short, that's all.
I like the brevity.
It is a failure to respond. But again, not anticipating the rulemaking period, I wanted to see if there was any appetite to add in the violation of the gift card rule. 1262.33, I think we just said.
I don't see how we could do that without a response.
This goes back. You know, do we want to do a little more to get their attention? Because maybe the $1,000 is just the cost of doing business, you know? So if they're getting 5 or 6 listings off this and you find them 1,000 every time you get caught, does that get your attention?
And that's kind of why I asked about the summary judgment. Like, is this, the information we have presented before us now enough to know, to do that, or do we have to wait for them to respond to that allegation?
So I would say that this respondent currently has pending cases that they have also failed to respond to. They have 2. They are currently set for hearing in front of an ALJ. And that there is, the advertisement is, I word for word took it from the advertisement. So.
Okay.
And I just want to point out, this differs from the conversation that we had earlier in reference to closing gifts, because this is an inducement for business. So I just want to make that distinction, since we had a robust discussion earlier today.
So would your recommendation be to go ahead and just assess the civil penalty for not responding and defer, or?
I only pointed out their history because of Commissioner's Begley comment about.
Right, cost of doing business.
Yes, sir.
Yeah, council's recommendation was for a $1,000 civil penalty for failure to respond. Is there a motion in the case? Case number 12.
Okay, but that's not the complaint. We're only doing a civil penalty because they did not respond. So we're not really responding to the complaint. We're only saying they didn't respond. Is that correct? So should we address the complaint along with failure to respond?
I think we have the discretion to do it, and we can sort it out after the fact in some way, I'm sure.
If they were to respond, we could always represent the information and represent this case.
Commissioners, what do you think?
I have a question on history. You mentioned there's history, and you've got none here. Is that because nothing is settled?
It's because they're pending. Yes,
They're
sir.
pending,
We are moving
okay.
towards resolution quickly, however.
Should it say pending cases on there or no?
No, because it's only cases that have been adjudged and closed that
Okay.
would show up on their history.
Commissioner Smith, you got questions?
So when you said several, we're talking, several can mean 2 or it can mean 10?
It's 2.
It's 2, thank you. And what kind of time frame are we talking about that those happened? Are they this year or in the last 5 years or?
They've been in the last 2. The resolution that I'm hoping to have, we could represent this, or I could bring it back. If they do respond, I could bring it back to you in February. I mean, that's
Okay.
the time frame we're looking at.
I guess my motion is going to be to increase the $1,000 to $1,500.
I don't think we can go that high. We can do.
You would or would not?
I don't think we can. I think our top is 1,000.
Is there a top of
You
1,000?
can, per violation, it's up to 1,000, but if you were to assess an additional civil penalty, it's 0 to 1,000. So I think the 500 is related to the underlying complaint, yes? So you
Yes.
could do a $1,000 civil penalty for failure to respond and then $500 for violating 302B A.
Okay. What she said. That's my motion.
So let's put the motion in then. So a motion is to accept council's recommendation to assess a civil penalty of $1,000 for failure to respond, but to add a $500 civil penalty for violation of the gift card rule. I have written down as Rule 1260-02-33 or Statute 6213-302B.
It'll just be the statute.
It'll just be the statute? Okay. So for the statute of 6213-302B.
I think it's 302A.
Does that sound right, Ms. Smith?
Yes, that is my
All right,
motion.
so that motion was made by Ms. Smith,
Yeah.
seconded by Commissioner Moffett. Any further discussion?
Yeah, I'm going to say
Commissioner
no. I'm going to say no to this just because I think we should be doing more. This is a principal broker that's not responding.
My concern, but then I was just told I can only do $1,000
Per violation.
per violation.
Well, now remember, the full spectrum of our sanctions is available, Commissioners. It doesn't just have to be a civil penalty. It could be dismissal, it can go all the way up to revocation. So whatever we think is appropriate in this
Which
case.
includes, downgrade, suspension, revocation. Those are the other additional, letter of warning, letter of instruction. That's the
Can-
full gamut.
Is it appropriate to comment on the other two cases that are before an ALJ?
No,
No,
no.
other than to say they're pending.
Yeah, I don't think you voted
Can-
yet.
Did I hear a vote for Commissioner? Okay, just checking. Thank you.
Yes.
So can you tell me a little bit more about suspension? How does that work, Anna?
So the only suspension works just like, as if we were to assess a civil penalty, individual has to agree to the suspension, but you can suspend a license for whatever period of time that you believe it to be appropriate. Months, years, not indefinite, because that would just probably be revocation at that point.
Can I ask how many agents are in this office? Is that a question
Sure,
I
we can
can
look it
ask?
up. I'll look it up.
Okay, thank you.
Question on the pending cases. Did I hear you say they were both on failure to respond? Could you say what the subject matter was?
I would prefer not to, since the
All
only
right.
civil penalty that's so far been recommended is for the failure to respond.
All right.
Did those cases come before us?
So, and since they're a failure to respond, I'm guessing they didn't respond to the consent order and it automatically went to a formal hearing? Is that,
I've had no response at all from this respondent on anything.
so that it automatically rolls over to a formal hearing
So
since they
I
didn't
have
respond?
been forced to go ahead and set for a formal hearing. Yes,
Okay.
sir.
And notice has gone out about that, and still no response?
Correct.
What's the date of those hearings?
The hearing is in January, which
January.
is why I said I could bring it back to, and give an update to you all in February.
I may have missed it. Did he pay the penalties?
No, there's been no
Okay.
response, no payment of any kind.
Do we know if this respondent is still alive?
This is a recent advertisement, so
Okay.
I myself checked that out and.
Okay.
Yes.
So do we want to go ahead and vote and see how it does, or do you want to
She's
withdraw?
looking to see how large firm that is.
There are 5 individuals, including the respondent.
So 4 affiliates plus the respondent?
Yes, that's correct.
But he didn't pay anything.
It's your motion, Commissioner Smith. What do you want to do? You want to proceed with a vote, withdraw, amend? What do you want to do?
Commissioner Smith, will you turn on your microphone, please?
I withdrew that motion, and we're going to see what the next motion would be.
All right. Without objection, the Commissioner Smith's motion is withdrawn. Any further motions?
I'd like to make a motion that we defer it till February meeting, and we see what happens in this case at that point in time. Because we may have an answer that we need to revoke his license or her license or something at that point in time.
Doing that, can we still leave the assess for civil penalty for $1,000? If you defer,
Deferring means no action taken until some future time.
so the recommendation could take place in the next meeting.
We would have the full spectrum available to us at the next meeting, yes. But this person would still have an active license to practice real estate in the state of Tennessee while we wait.
So do you typically, when you have these hearings, do you bring the results to us? I mean, well, is that something you usually do or can do?
Not usually, but it's certainly within your purview to say, I'd like to know what ends up happening with this respondent.
Okay.
It would go to the history of the respondent when you hear it in February.
So Commissioner Gahn made a motion to defer. Is there a second? Last chance. Hearing none, that motion fails on inability to obtain a second. Is there another motion?
If we suspend their license, how long is that suspend? Do we have the option to do that, or is it only revoke?
We have the opportunity to suspend for a period of time, not indefinitely, because that would be a revocation, like Ms. Matlock said. So you would have to specify a period of time, and they would have to accept it. And since we're not getting responses,
How quickly did they get that conveyed to them? If we say we suspend their license, did they find that out today?
They would find out within 30 days.
I make a motion to suspend their license until our February meeting.
That won't work
Yeah.
because it's very unlikely that
They'll respond.
the only way it would work is if the respondent were to sign the consent order,
And
and
they're
since
not
the
responding.
respondent hasn't responded to anything, it is very likely this matter won't end up for hearing related to it. So, again, we can only suspend a license if they agree to it. So, if you wanted to suspend their license, it would need to be I would remove it from attachment to the hearing, but to the hearing.
so
yeah.
would you, like, 6 months would be a good time frame?
I mean, 6 months, 3 months, whatever you guys, it's up to you. You can decide how long you wish to suspend the license.
I've got a question at some point.
Well, I want something to get their attention enough that they will respond, because the civil penalty clearly is not enough,
Right.
because they're just ignoring all of that. So
So
what is it going to take to get
I
their
remember-
attention to respond?
I remember at our meeting in Kings Point, there was a voracious appetite to revoke licenses.
Yeah.
Yeah, that was a day.
That was a day. I'm not sensing that kind of appetite today.
Okay, I'll make a motion to suspend their license for 6 months.
All right, so I have a motion to suspend this licensee's license for 6 months. Is there a second?
Beginning as soon as they get that information relayed to them. Beginning today, 30 days notification from today, I guess.
So that motion was made by Commissioner Torben. I heard Commissioner Bagley. Did you second that?
Are we including the $1,000 penalty too?
That wasn't part of the motion, no.
Can we do that? So still include the $1,000 for failure to respond and suspend the license. Okay, I amend my motion.
Okay, motion has been changed. Commissioner Torbett says she will accept council's recommendation to impose a $1,000 civil penalty for failure to respond and suspend this license for a period of 6 months. And that motion was seconded by Commissioner Bagley. Commissioner Gwynn, you have questions?
Yes, this is maybe for Anna. As it relates to communication with a principal broker, does a principal broker have any kind of duty to inform the affiliates that work under him that he or she has been dealing with TREC on issues? And my concern is that there are 5 people working for someone that's, dealing with possibly losing his or her license and they don't know it. Is that a fair assessment of that?
Yes, there's no obligation of the principal broker to disclose that information.
Okay.
So, but if his license is suspended, he can't be the broker.
Correct, that would be correct.
So what happens to their,
They would need to transfer their licenses to another firm or put their license in retirement.
and if he won't sign the TREC one, then
Or one
he's,
of them upgrade to a broker if they're eligible to do so.
So what can't turn on, there we go.
oh, I'm sorry.
So what happens with, the license is suspended, but his agents aren't aware of it?
I mean, we can communicate that information to the agents following the suspension.
You can or cannot?
We can.
Okay, thank you.
But also remember that that depends on whether or not this licensee accepts the consent order to suspend his license.
Right, but if they were suspended, we can communicate that information to the licensees because we'll have to, send an email to Denise at some point asking them to suspend this individual's license.
So let me be sure I heard this one more time. This broker signs the consent order,
Yes,
and he or she realizes the license are suspended
yes.
until the hearing, correct?
If this individual was to sign the consent order, that would mean that they would owe us, if this motion were to pass, $1,000 and their license would be suspended for 6 months. And they would still have a formal hearing before this commission because they have other matters pending.
So they could come, when they come before the commission for the other matters, then they could ask for their license to not be suspended anymore. Is that correct?
Well, the hearing is set before an administrative law judge alone.
Okay.
So you guys won't be hearing those matters. But I would not believe that would be something that they could do, as it is, their suspension is related to another disciplinary matter. So at the hearing, I don't believe they would be able to ask for their license to be set to active.
So at what point could they ask? Would that be another hearing?
If they were to sign the consent order saying they're suspended, the only time they would be able to set their license back to active is at the end of the suspension.
6-month
Yes.
suspension that we enforce?
Yes.
Okay. Okay, thank you.
Am I hearing you right that they have to accept it?
Yes.
And if they don't accept it, the license stays active?
Yes.
Until
The only way, this has always been the case in every single thing, is the reason is because there's this thing called due process, and people have to be afforded that process and related to this. So you guys are assessing a civil penalty because you believe that there's been a violation. However, if it goes before a hearing, it could be that there isn't a violation, right? So if we're thinking, in terms of let's do a criminal matter since that's easiest for most people. You're presumed innocent until you're guilty. So it could go that the person would be found at trial not guilty. And so because your license is considered to be a property right, the only way that we would be able to immediately suspend someone is a matter called summary suspension, and that's when we believe that the health, safety, and welfare of the public is at risk. And that's a pretty high burden to set, and I don't believe it would be appropriate for this matter, considering the amount of time that's been elapsed at that point. We've only had, I believe with you all, one summary suspension, maybe not all of you, maybe just Jeff, and that was related to a theft case where an individual had sold property twice. So we're thinking of the most egregious matters in those circumstances. So we can't make anyone do anything until their rights are fully exhausted, which is why we can't immediately suspend their license.
So if we revoke their license, then they have to come before a hearing with us.
If they don't sign the consent order, yes. Now, some people, we have had individuals that licenses have been revoked and they've signed the consent order and then it's revoked. But if they decline to sign the consent order or do not respond to the consent order, then they would come before the commission. And I believe this case would come before you all because it does contain failure to respond, but it also contains a violation of 302B, which has not been delegated to an administrative law judge.
Are we complicating things with, as it relates to the other two pending cases?
No.
Should we,
Those
or
are
not?
completely separate. So
Completely separate.
those will still proceed as normal.
And so it doesn't make sense to hear this one with the other two as well, right?
You can, let's not even think about those two cases as being pending. You can go ahead and assess the discipline for today, and then those cases will still move forward. The only thing that would maybe possibly complicate the matters is if for some reason at those hearings, let's say Kim's feeling spicy and she recommends revocation and then their license is revoked at the hearing, that happens, then we kind of have a little wrench in the area. But it's fine to go ahead and proceed with this now and not worry about those two.
So from a timing perspective,
Yes,
if we agree to this, we revoke the license, we communicate it in the next week, correct?
correct, yes.
And then he or she has how much time to respond to that?
The typical time period for a consent order is 30 days.
So 30 days, they could wait for that whole 30 days and then say, I disagree, I don't agree with that, okay?
Right.
And then how long does it take to get to a hearing, roughly? 60?
So if we were to follow it at that point, the earliest that a hearing would be able to be set in this matter would be April, because we have one that's already set in February.
So the 6 months,
Would not
is-
start running until the conclusion of a hearing or the
Okay.
signing of a consent order.
so the 6 months is not really doing anything, is it?
I mean, if
For 6 months, I mean,
there will be a time period where that individual's license is active, but then if we go to hearing, then their license will be suspended for 6 months at that time. Or if they sign the consent order, let's say in a week, they decide for some reason that they would like to suspend their license to be suspended, it will be suspended as of the date of the consent order.
What frustrates me is someone continuing to not respond to this body. So I just want to do something else to try to force them to respond. So a suspension, I feel like a suspension is more warranted than revoking, but, I mean, I'm open for discussion there, but I just want a response. Just respond.
seems to me like a suspension muddies it a little bit versus a revocation. A revocation with no time frame, you just deal with whatever the time frame ends up being. Whether it goes to a hearing, it takes 6 months, it takes 3, it takes a year, whatever. But you put the person on notice in a, declarative way. We're revoking your license, period. You go deal with it.
So, Ms. Matlock, even the question about when the next hearing could be scheduled, that's a negotiated process between you, the defense, and the judge, right?
Correct.
So
But like
it could be
timing-
April, it could be,
Yes, yeah, it could be
June.
April, could be whatever, yeah, June. But the earliest that it could be set would be April.
Could you repeat the motion that we have?
sure. The motion is to accept council's recommendation for failure to respond, $1,000, to impose a civil penalty of $1,000 for failure to respond, and to suspend this licensee's license for a period of 6 months for violation of, and I'm sorry, I lost it. Was it 302B? Violation of 6213 302B.
I have one more question. once that suspension time is completed, how do they get their license back active?
I'm sorry, can we repeat the question? Oh, once suspension is completed, it depends, their license, we would send an email, that the license, period has been, it has elapsed. But also in the consent order, we can require, certain things before their license is reinstated. So, if you wanted the individual, I don't know, for some reason to come before you in like an informal appearance, at some point, that would be an option, but really I only attach that to revocations, as the discretion for a suspension at that point. If you were to say, no, I don't really believe that person's license would remain suspended unless we put that there.
So are there fees to be paid to bring it back out of suspension?
There wouldn't be.
Okay.
Unless their license expired.
Okay. I'm good. We have a motion on the floor.
We do have a motion that's been made and properly seconded by Commissioner Torbett and seconded by Commissioner Bagley. Is there any other discussion?
I'd be open to having that motion either fail or be withdrawn and move for a revocation.
I would agree.
I'm open to friendly
Friendly amendment?
amendments.
Do you want to withdraw it and allow them to make a clean motion?
Sure, I'll withdraw it and someone can make a different motion.
All right, so Commissioner Torbett has withdrawn her motion. The floor is now open for a new motion.
I've got a question before I make a motion. Is it appropriate for us to communicate to the affiliate brokers in this brokerage? In other words, we let them know what's going on? Is that, we can't do that?
I mean,
Without denying this person's rights,
I technically think that you could, but again, we would just be telling them, hey, your broker's got a consent order out there related to suspension, however, revocation. However, it won't be determined unless, until
Correct,
hearing.
right.
So
I just hate for them to be blindsided on something.
I'd hate for them to be blindsided, but I would also not intend to undermine a broker's office by having all of his brokers leave when there proves to be no issue for them to have left other than he or she not responding. I mean, I would want to know, but it's not affecting their licenses yet. So I think I would be of the mind, unless I hear otherwise from council, is to just act on this respondent
With no notice to the other,
with no notice until it is revoked, which means they come before us or they sign the consent order. And at that point in time, it is policy for the licensees to be made aware, because would then have to one of them would either have to upgrade their license or do a TREC 1 to transfer. But until that happens, it's not going to affect their licenses or their ability to practice.
I get that.
And
But-
if this is a big misunderstanding, if he or she have had something that has not allowed them to respond for 3 cases, we wouldn't want to then have made all of his brokers leave, or their brokers. I don't know if it's a he or she.
I'm afraid to ask. Is there any further discussion?
Do you want me to call the question?
At your discretion,
We
Commissioner Torbett.
have to have a motion. Nobody's made a motion.
Nobody's made
Somebody
it?
did make
No, Steve was about to, and then he had a
But he
question.
had a question. Okay, I'll make a motion.
Go ahead.
Similar to my previous motion, except to accept council's recommendation for a civil penalty of $1,000 for failure to respond and revoke the license of this broker.
All right, so I have a motion made by Commissioner Torbett to also accept council's recommendation for failure to respond and to revoke this license for violation of 6213-302B, seconded by Commissioner Gwynn. Has everybody said what they wanted to say? All right, hearing no further discussion, let's vote. All those in favor of the motion, please say aye.
Aye.
All those opposed? Hearing none, the motion carries unanimously. My goodness, okay. I didn't know case 12 was going to be,
I'll do my part to keep
Such a
the,
small
keep the
narrative.
others moving more promptly than that.
all right. Case number 19 is a discuss. Ms. Cooper, what do you want us to know about case number 19?
Case number 19 was an administratively opened complaint against this broker. My concern is that we have a broker, a firm, and an affiliate that have all been assessed civil penalties or recommended civil penalties for unlicensed activity and are continuing to conduct, from what I can tell, unlicensed activity.
So, not knowing what was going to happen in case number 12, my first note to case number 19 was revoke with a question mark.
I move to revoke.
I have a motion by Commissioner Ferris to revoke this license, seconded by Commissioner Smith. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
All opposed? Hearing none, that motion carries unanimously. Case number 20. That's both of us. Ms. Smith, you want to go ahead and go first?
This is where, if I'm not mistaken, this is where one of the agents got upset, and so they said some ugly things on the social media about the contract, the buyers, the sellers, and everyone. So you're suggesting a $500 civil penalty for failure to provide services for each party. I guess I want to increase that, if I can do that.
Yes.
I would like to increase that to a $1,000 civil penalty. I think we need to take social media more serious, that when we post something or we put it out there, that we got to realize that we're not just talking to the person that made us mad, we're talking to everybody that can see it. And these were some pretty harsh words that were said. So I make a motion that we increase the civil penalty to $1,000.
Before we take a second on that one, my note was to add education to it. And, just so happens that in the December education report, there is the Greater Nashville Real Estate Association has a Lead to Succeed course, which is 6 hours, which talks about communication skills. And I thought that would be very useful for this licensee to sit through, and I would say it could be completed in 60 days and not count towards CE.
Are you specifying that particular course?
Yes.
I accept your recommendation.
So it says classroom, but I don't know how GNR will present it. But if they have to go to a classroom, then I think that's good.
Then make a drive.
So that if I can restate the motion.
Can we compel someone to drive somewhere to take the class?
You compel someone to say these bad things.
Well, and to be clear, I was getting ready to pile on more than 1,000, but I'm rereading this, and the respondent did not say these terms, or at least it's not very clear that they said. Commenters to the post made some of these remarks. So just an FYI, but I mean, they still, yeah, they're in the wrong. $1,000 is totally agreeable. I was gonna make a remark like, hey, $1,000 for each one of these terms, but they didn't say that. They didn't say some of these things. So
That would have been a lot of money.
that'd have been a lot of money. You'd really watch what you say. But I don't know if we can compel somebody to drive, but
Right, I was gonna just recommend if we had a class related specifically to like communications or the other,
That's good
because we
with
may
me.
have existing courses and we can approve it. It would be something, that they would take and we'd be like, okay, this works. Not like when individuals do submit their continuing education, we do try to make sure that that is the course that they're supposed to be taking related to that. And also, my concern is designating, I don't want it to look like the commission is favoring one association over another
Fair
by
enough.
selecting a specific course.
And I don't want the education to be a 1 hour, 2 hour.
Right, so you can set the hour amount and the general subject matter, but I would refrain from picking specific providers.
we could do the core course because there's some ethics piece in there.
And another one?
And another one, yeah, I mean, specific,
Is there one that's specific to social media?
I imagine that there is.
You could
that,
do a social media and/or communications course. Those courses range, they hover around the 4-hour mark, 2 to 4.
So a core course and a social media / core communications course,
Okay,
not
so-
to be counted towards continuing education.
So the 6-hour core course, the 25-26, not to be counted to the 25-26 that will start next year, as well as a communications course with a minimum of 4 hours.
Yes, communications / social media. I don't know if that would be different. Who made this motion? Did you want to say that? I can't change your motions. That was just a suggestion.
so
Just
I'll-
a suggestion.
I'll try to restate. Commissioner Smith makes the motion that we increase the civil penalty for failure to provide services to each party to the transaction with honesty and good faith to $1,000, to add education components of the 24-25 core course. It's not to be counted towards their continuing education credit, and a course related to communications or social media for a minimum of 4 hours. That is also not going to be counted towards their continuing education. And I think give them, 180 days to comply?
I'm good with that.
And to be completed within 180 days. So that's the motion. Commissioner Torbett, you want a second?
Second.
Commissioner Torbett seconds the motion. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
All those opposed? Hearing none, that motion carries unanimously. Number 24. I pulled that one. Joan
I
also.
pulled that one, and I pulled that one because it says respondent company did not respond to the complaint. So should we not have a civil penalty for did not respond?
Well,
They're not a licensee.
They're not licensed.
They're not licensed. Thank you for that.
Yes, ma'am.
But I wanted to.
So the question also that I wrote down was, is it possible to refer to another board? Is there some other board that may have jurisdiction that we don't? Is that the right one? That's the right one, yeah.
Not that,
Not that,
I'm
not
aware
that you
of.
see in the face?
no,
Okay.
sir.
Okay, then I make a motion we accept council's recommendation.
I have a motion by Commissioner Smith to accept council's recommendation in case number 24, seconded by Commissioner Moffett. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Case number 25. Joan, you and I pulled that one also.
You can go first.
I can, thank you. It's one of the discuss options too, so.
I asked for a discussion because I wasn't quite sure what to do with this one.
Okay.
The statute specifically says that refusal to permit access will trigger disciplinary action. I don't know that this respondent willfully refused access, but they're also not providing, despite repeated requests for specific information. But when they came back and asked for a sample of what they could provide, it just seems like they may be lost in the weeds a bit. So I didn't know if a letter of instruction might be appropriate. I didn't know if, based on your professional experience, if it's really that difficult to comply. That's out of my wheelhouse, so I
Yeah.
wanted to present it to the commission.
No, it seems from the narrative that their bookkeeping is a salad, so.
Yes, sir.
Is there a time frame? And
The auditors work with them and give them a time frame in which they have to respond. And this audit, if I remember correctly, the auditor attempted over a period of 7 or 8 months to try to help this respondent do what they were supposed to do and just could not get them to figure out, I'm not sure how to put it, to give them what they needed.
So,
And audits now are done by online. In essence, you.
They're
send
desk
your-
audits,
they're
unless-
desk- You send your information and you send it back. This one made me want to send the auditor in person. And I know we're not doing that, but it really made me want to do that.
I mean, we could send an investigator there to get their files and then have the auditor review them, but they're not providing what needs to be provided digitally.
Is there a fee if an investigator comes to your office.
TREC is charged, yes.
And so in essence, this firm is charged.
We don't necessarily request for reimbursement.
Okay. Is there typically a civil penalty that we can assess when they're not responding like they should?
I would hope the commission sees that there is value in audits and
Right.
take a stand saying you need to comply to make sure that funds are not commingled, if that was the commission's point of view.
So the statute quoted is 6213-312. So that would be, how would we assess our penalty?
Are you making a motion?
I was just going to suggest, what if there was a motion to revoke unless the required documentation is not submitted by end of quarter one of 2025?
So 90 days, 120 days.
I think that's a long time. We've already had 7 months.
I know, but there's, by the time the wheels of government turn this around, and as fast as we are, as you guys are, which are the
Thank you.
fast in the nation, let it be stated on the record, there's no finer group anywhere in their union. But it just takes time for these all to get out. And, but yeah, I'm fine with that. End of January, end of February.
Okay,
So my motion would be to,
Wait a minute, I think she stopped.
okay,
I just want to, we were at 120 days, now we're about 90 days if it's the end of February. Oh, okay.
I mean, this has been going on since April, correct? And the person hasn't been able to get their books in order, basically. They said they've gone out and hired somebody.
They've sent stuff in, the auditor requests something very specific, and they send something else in. It's like wanting to watch a basketball game, but baseball's on. We didn't ask for baseball, we asked for basketball. Yeah.
So this has gone from cooperating and trying to comply to it almost sounds like they're stonewalling. Seems like that's where you're at with it now, is where
It's
they.
either some extreme incompetence or it's stonewalling. I mean, like I said, they seem to just, based on what I saw, they are either extremely lost or it's not possible to be that lost.
Okay, I have another question. So we can revoke a firm license, yes or no? So we, in essence, because we're talking about a firm, but we're also talking about the principal broker. So we're talking about a revoking of the firm license or the firm and the broker?
What's before you now is the firm. There would have to be a complaint opened against the specific broker if we wanted to move forward against that license as well.
Okay. Are you looking for a vote, a motion?
I'd love a motion.
I'm going to struggle with this motion a little bit, and I'm going to ask for a $1,000 civil penalty. And then I'm going to ask for a revocation of the license. What else do I need to say?
Giving them some time.
That's what I'm thinking, end of February.
So wait, so revoked starting at the end of February? Sorry. So revoke starting at the end of February if they haven't complied?
Tell me what you want, and I'll see how we can do it.
I don't like that they're not responding. I got an audit request the first week,
Right.
remember?
Yes.
And that was not on purpose.
And it is challenging to get all of it together. But it's the responsibility of the broker because that's the role they assume.
Correct.
So I think the firm should be assessed a $1,000 fine
Okay.
penalty
So, let me
because you
see.
don't have your stuff together.
Right. So we want to, let's say, a $1,000 civil penalty, and then they have either 90 days to comply with the audit, but if they do not comply with the audit, their license is to be revoked.
That's what I said.
Okay.
Second. So Commissioner Smith makes the motion with assistance from Anna Matlock to assess a civil penalty for $1,000 for failure to respond and to offer this licensee, we say 90 days? 90 days to comply with the audit request or have their license revoked. And seconded by Commissioner Moffett.
Discussion?
Commissioner Gwynn.
I don't know that they didn't respond. They didn't respond as requested, correct? So they didn't they just didn't respond properly as the auditor asked. Is that?
They did not provide the required documentation to complete the audit.
So, for example, if the auditor said, send me 12 months of escrow bank statements, and they sent 3 instead of 12,
That would be incorrect. That would be a failed audit.
okay.
You have to
So it's like
provide
sending,
12. So it's like if they send us $10 for their $1,000 civil penalty, they have not complied with their civil penalty because we don't have the full amount that was requested. So you comply with everything that's requested in the audit, or it is not, you have not complied with the
At
audit
all.
fully.
Okay, I have one question. So we've given this person 7 months to complete their audit, and that has not happened, correct? Is there a timeline on completion of audits?
Yes, usually they're done within 30 to 60 days. The auditor went back and forth with this person a dozen times, maybe. And, you know, asked for an apple, got a banana. Asked for an apple, got an orange. Asked for an apple, got a peach. It was never the specific documentation the auditor needed
Okay.
to complete the audit.
Okay, I'm good with my motion.
So I think when I restated the motion, I misspoke. I said failure to respond. It was failure to comply with 6213-312, which is refusal to permit access shall constitute grounds for the commission.
There you go.
Yeah.
So that is a failure to comply with a audit request. So just so I can restate it for the record, it's the assess a civil penalty of $1,000 for violation of 6213-312 and to give this licensee 120 days to comply with the audit.
90 days.
90 days
90
to
days.
comply with the audit request or have their license revoked.
So
And it was seconded by
so
Commissioner
the
Moffett.
complaint is against the firm, so you're revoking the firm
The
license.
firm license, that is correct.
That's the motion, yes.
So this broker could open another company the next day.
We don't have a complaint against the broker. This is a complaint against the firm. You can open a complaint against the broker.
We can open a
correct?
complaint against the broker, and my suggestion would be to do a heavy penalty for not having done this, and then open the case against the broker to hear this matter as well.
So we're at the maximum for the civil penalty amount of $1,000. And then the revocation, whatever you would like to do at that point. But we can administratively open a complaint against the principal broker.
You can or cannot?
Can.
Yeah.
You can amend your motion.
We can
to
amend the
add
motion to limit the civil penalty to the firm, and then instead of discussing revocation in relation to this complaint, we can have the back end of it say administratively open a complaint against the principal broker for the violating the same statute.
Is that what you're asking for, Mike?
I, we can still revoke the license and then assess the responsibility against the broker in a separate matter. So, like, if technically, you know, if they were to agree to it, yes, this firm would be revoked and they could open another one, but we would be addressing their individual license with the administrative complaint. So,
Yeah, I like that.
I think the only thing we would need to do at this point would be to amend the motion to include opening the administrative complaint against the principal broker of the firm.
Correct.
So Commissioner Gahn is offering a friendly amendment to the current motion to administratively open a complaint against the principal broker for violation of 62-13-312. Commissioner Smith, do you accept?
I accept. I accept.
So the motion, restate it one more time, please, is to accept counsel's, did I say that right? To assess a civil penalty of $1,000 on the firm license for violation of 62-13-312, to provide the firm 90 days to comply with the audit request or have their license revoked, and then to also administratively open a complaint against the principal broker for this firm for violation of 62-13-312. And that was made by Commissioner Smith, seconded by Commissioner Moffitt, and with a friendly amendment from Commissioner Gahn. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 27, that's me.
Jeff, before you go to the next one, could I
Yes,
ask
sir.
a question?
Absolutely.
Relative to audits? In the event an auditor finds fraud in auditing, say, an escrow account, how does it work? Does the auditor make a recommendation to you, and then you come to us? Is that how it works?
Yes, the auditor will submit to the firm that there was a finding, and then we administratively open a complaint, which then goes before you all for review.
Great, thanks.
I believe you guys have assessed penalties for commingling of funds this year, as well as failure to respond.
Case number 27 is about an advertising violation. I don't have disagree with counsel's recommendation, which is for a $250 civil penalty.
There's a typo. I said both 500, and then when I put the numerals, I put 250. So what I meant was the 500, just because that's the standard for advertising violations. So I apologize for the typo.
Okay, so the recommendation is instead for $500 civil penalty for violating the advertising rules. I wanted to also administratively open a complaint against the principal broker for failure to supervise. That's what I thought was missing out of that one.
Is that a motion, Chair Diaz?
Not from me, no. I was hoping another commissioner would do it.
I'll make that motion for you, that the civil penalty be $500 and then a complaint be opened against the broker.
So I have a motion by Commissioner Smith to accept council's recommendation for a civil penalty of $500 for violating the advertising rules, and to administratively open a complaint against the principal broker for this firm for failure to supervise. Is there a second? Second. Seconded by Commissioner Moffitt. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 28 is a represent. Kim?
Yes, sir.
So they
That's
settled
not a
in
short
one.
one.
So what I wrote down is this, and maybe I got the dates wrong, so help me out if I did. And I thought the earnest money wasn't distributed as required under the statute. Is that?
It was not dispersed within 21 days, no, sir.
So I mean, I feel like, I don't think we should have to change our original finding because they still didn't comply with the rule, even though they settled it out of court somewhere else. That would be my sense, but.
I think since they've complained has requested to withdraw the complaint, how have we faced that before? I mean, once the complaint's out there, it's out there. They can't withdraw it, right?
Once a civil penalty's been authorized, it can only be dismissed with your approval. Based on the age of the case and the fact that it did go through the courts and the complainant has now said, I'm good, let it go, that's why I'm representing it.
Yeah. I'd move to accept council's recommendation. This was opened in May of 2021, which just another reminder for everyone within hearing. Man, may you be spared ever having to be in a case like that.
So council's new recommendation is to dismiss. Commissioner Ferris made the motion to accept council's recommendation to dismiss, seconded by Commissioner Gwen. Any further discussion? Hearing none, let's vote. All those in favor say aye.
Aye.
All opposed? Hearing none, that motion carries unanimously. Case number 32. Joan, you pulled that one, but that was a discuss, so.
That was a discuss. That's why I pulled it. So Kim, you want to review us?
It was one of my cases. Sorry, my voice is not.
Ariel, I'm sorry, Ariel, go ahead.
Sorry. So for this one, it was mainly about a duty. The complainant was saying that they, sorry. Good gracious. They didn't properly disclose a material defect with the property. So essentially, the seller knew that there was something wrong with the flooring and they just noted it as uneven flooring. But the complainant believes that it was a structural issue. The respondent said that the complainant has no ability to, I guess, name it as a structural issue. And they included the quote that they originally had before it was listed. And it seemed like it was just reported that they needed additional support for the foundation and the flooring. So from the respondent's perspective, they have properly disclosed everything. And so I brought it to the commission because didn't know where essentially that line was, where the respondent just said like there was uneven flooring and that they did acknowledge that in the property disclosure form, or the complainant was correct, where the recommendation for the quotes were beyond just uneven flooring.
Is there any indication in the record that the respondent saw this quote for the floor repairs?
Yes, it seems based off the timeline, it was like before they even listed it, they had the quote done, then it was listed, and that's the basis on why they went with the pricing.
Yeah.
Was because of the
Right.
quote they got.
I mean, I'm looking at the line items that you said about supplemental beams and floor joist sisters and floor support system, and, well, that sounds more than just uneven floors to me. I mean, Joe, that seems like a significant repair and not just, some kind of, or a less complicated repair. What do you think?
Well, yeah, it sounds like they had a quote for all those repairs, but they didn't. In the first paragraph, it's saying that they reduced the price because of that, but I don't think they conveyed to the buyer that was the reason the price was reduced. In their mind, they may have thought they reduced the price, but probably should have presented that, I think they probably should have disclosed it.
So did they purchase it, or they just were a prospective purchaser?
They're just perspective. They didn't go forward with it because they didn't appreciate that it wasn't disclosed.
That's the lesson in and of itself to the respondent. Not saying that's the only lesson they should learn here, but there's just a few circumstances where you can over disclose. But I think they did a halfway good job of disclosing. They did say that there were uneven floors, and that.
I mean, is it uneven floors or are the floors a trampoline? I mean, everything's plural. Sistering of beams, floor joists, like, this is not one floor joist. This is, hey, I'm going in there and it looks like somebody, took a hacksaw, did a floor joist. I don't know.
Why is the broker complaining versus the buyer?
I'm not sure. I think
There wasn't a buyer. The buyer didn't proceed with the deal, so the buyer walked away.
The complainant's upset. see it, because they were not able to keep their buyer.
We lost a deal,
We
man.
lost the deal because you didn't tell me.
At least that's what they're saying.
So, I mean, the Ariel pointed out 6213-406C, talking about no imputation of knowledge. I think is this the listing agent that we're looking at right here?
Yes,
The
the
respondent?
respondent was the
So-
listing agent, and they represented the seller. But I just think that normally there wouldn't be an issue, but it seems as though they knew about it beforehand.
Yeah.
Yeah, and the respondent is going to, I can't assume how the respondent will respond to this motion if it passes, but they will, I mean, based on the text here, they believe they've disclosed what they should have, and the seller does as well. But I move to issue a $500 civil penalty to the respondent for not fully disclosing the condition of the floors and the quote to repair the floors.
So the statute for that, if I can add to it,
Yeah.
is 6213-4032.
Correct.
So it'd be a, Commissioner Ferris makes the motion that we issue you said it's 500?
Yes.
A $500 civil penalty to this licensee for violation of 6213-4032, failure to make proper disclosures. That was seconded by Commissioner Smith. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 40.
Okay, this is also similar with duty to disclose. So the parties had entered a binding agreement, and before they entered it, they had known that there was like a tenant that was living there.
Oh, my. Okay.
And they're supposed to leave before the closing. It didn't happen. It was, the date was changed a couple times, and one of the times, like in the earlier times, maybe the second or third time, they changed the closing date. They wrote in the agreement that it would be the seller's responsibility to get the tenant out
Right.
and all of their property as well. It wasn't done. And then by the time that the seller moved in and everything closed, they were still there, and they had an eviction notice saying that they could stay on the property essentially for like 30 more days.
So
And
you're nice, Ms. Carter. We have to understand that this tenant or squatter,
Yeah.
you said is the respondent's son?
Yeah. Yeah,
Okay.
like our relationship there, and they were just kind of
Oh, my goodness.
staying there.
So, and the respondent, the broker, the respondent for this transaction, they don't own the property in question? That's somebody else's property that's vacant, that they're selling?
So the respondent, I don't think they have any kind of ownership in it, but, oh, sorry. It was
No
the
ownership
se-
interest?
Oh,
So
sorry.
it's just a vacant property that her son is sitting in?
Yeah, it was
that
like
she's
the
trying to
sellers.
sell.
I think they just probably just know each other and it's really weird. But,
All right, I'm
hold on,
sorry.
let me just read it again.
So the respondent, this is a listing they have of somebody else's house?
I may have miswrote that. I'm sorry, that might be a typo, but essentially it was the seller's son. I don't believe that the respondent is the seller. I apologize. That's a typo on my end. If that.
So the respondent is representing the owner of this house in question,
Correct.
but her son,
But
The seller's son.
son.
the
is
seller's son, I see.
Yeah.
So I
Okay,
apologize if
Okay.
that's in there, then I'll like to change that.
Man.
But either way, there's a seller's son is there.
so, okay,
Not the respondents.
Yeah,
I see.
so
Okay,
I apologize.
man.
Do you have
Sorry,
proof?
there were a lot of parties, and I've
Yeah.
always got.
Do you have proof that they did a walkthrough prior to closing or anything?
Okay.
I believe everyone acknowledged that like a walkthrough was happening, and that the person was still there. I think they all acknowledged that they were still there. I think the issue was the timeline on the. I think the complainant called them a squatter. The
Right.
respondent called them a tenant. I went with the tenant because it was like a nicer term. I felt like.
But the buyer went
But-
on and closed the
But
property,
they continue to close.
although they walked through and saw that someone was still living there.
Right. I think they went through because at one point, like the second to last time it was supposed to go for a closing date, the police were there and they were told that they had been removed from the property. And sometime in the interim, they had left the property, but then they came back, and they, like, apparently no one was aware that that was happening. So,
So it seems like the respondent tripped up on these dates when the seller's son had to be out of the property. Instead of saying a date certain around closing, it was some other date imposed by a court where they had 30 days to get out, and that was some time period after the closing date?
yeah, so, the agreement was that, from my understanding, what the respondent was saying is that, like, everyone was under the impression that the person would be out of the property, that tenant would be out before the closing date, and it'd be good to convey, without any person in there. It just seems that they didn't have anything officially pushing them out. And so the seller had to go to get an actual eviction.
The seller or the buyer?
So the seller had to.
The seller is the one who apparently went to the court.
So the seller had to evict their own son out of the house?
Yes,
Okay, so there's an order by a court that is saying you have to vacate? And
yes,
that gives them some time period to vacate?
yes.
I don't see anything blatant that the respondent did wrong.
Yeah. Aside from not knowing the date when the tenant had to get out of the property.
And we only can know what our clients communicate to us. My motion would be to dismiss.
Is that your motion?
I move to dismiss. Case.
So Commissioner Ferris made the motion to dismiss. There was a race to second, but I think Commissioner Gahn beat Commissioner Gwynn. So it was seconded by Commissioner Gahn. Any further discussion? All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. I think case 55 was also a discuss? Or represent?
I believe.
It was a represent, but not a discuss.
Okay. So represent, your new recommendation in the case is to close and flag.
I believe you guys accepted the close and flag recommendation during the consent agenda. Did I misunderstand?
I think, yeah. I
Did
think
you
I pulled
pull?
it.
50 I
pull
did
it.
not write 55 down. I'm sorry.
Commissioners, do any of us have questions about case number 55? I'll give you a minute to review it. Oh, okay. Well, this is, you have a complainant that's unwilling to participate in a formal hearing process?
Correct,
So we
yes.
can't go forward anyway, so I think, what would be accomplished with close and flag? What are you trying to do there?
The reason I wanted to flag it is because it was an advertising situation where I felt like the respondent just wrote just things that were like not professional, and so I wanted to keep an eye on them to see if they continued that kind of behavior kind of going
All
forward.
right, so you're looking for a pattern?
Kind of, yes.
Okay. Is there a motion to accept council's recommendation to close and flag case number 55?
So moved.
Commissioner Torbett.
Do you want to second that, and then I'll have a question? He did second it?
All right, so Commissioner Ferris made the recommendation to accept council's recommendation to close and flag, seconded by Commissioner Moffitt. It's time to discuss. Commissioner Torbett.
So my question is, just so that I understand this correctly, the respondent was willing to go to litigation, or was willing to accept, like, I can't figure out why we've gone from all of these penalties to just close and flag.
The respondent did not accept the consent order, and we were going to go forward with formal hearing. And in
And then the
preparation,
complainant didn't want to.
and then in preparation for it, I didn't have a cooperating witness. And based off the nature of this complaint,
Okay.
I felt like they were needed.
That was my only.
So without the cooperating witness, we're back to the consent order, right? That was been denied, been refused by the respondent. So then we were back at, so
So then we would be back at formal hearing.
formal hearing, but we don't have a cooperating witness to
Correct.
proceed, so
So,
we get this loop. So seems like closing flag is the best way. Any further discussion?
Seems like a get out of jail free card to me.
It kind of does, yeah.
We don't close the flag forever. Does it have an end date on it? Or what, how's that work?
I believe it says on their profile, and then if there's any issue, then we can like bring up additional questions.
So
for them to resolve.
we close and flag, do we have to look at it again, or no?
only have to look at it again if like the same behavior or something else comes up again in the future.
But we don't have to check it or anything like that? Okay.
Any further discussion, Commissioners?
I mean, I'm just rereading it again, just because I agree with Stacy. It's a get out of jail free card. And the respondent has some remarks here that we need to weigh. You know, respondent stated the complainant wouldn't allow showings of the property unless they were present. It was difficult to schedule showings. Respondent stated that complainant wouldn't allow them to come to the property to take pictures. That's not a situation we often find ourselves in as practitioners, but that would definitely impede the ability to represent somebody. I do think if there were any disparaging remarks from the licensee about the individual, that is not okay in my book. And we're not called to that level of integrity by any stretch. I don't know if Stacy, if we want to like, you know, we had voted. What were the penalties for specifically? I know the statutes are here, but what are they?
You seem, I said Jeff probably knows off the top of his head. He seems to know that book very, very well.
Yes, he does.
You spouted off without looking.
Why can't we just go back to the original decision?
Need to cite it to them?
No, based on what they actually.
Okay.
Because they didn't accept our
So
recommendation.
4031 is for violation of reasonable skill and care. And 3121, I want to say that's a false or misleading statement, but let me make sure that's right. I don't know. Hold on. 312 is making any substantial or willful misrepresentation.
Did we see the social media post? Was that provided?
I believe a redacted copy was provided when it was initially presented. Yeah.
What if we just take away one of the civil penalties?
Commissioner Torbett, we can't hear you. Thank you.
What if we just take away one of the civil penalties and leave a civil penalty for reasonable skill and care?
I
And then
believe-
see if they would accept that?
That could be a motion
I believe there's an open motion on the floor
If there is,
for
made
closing
by
flag.
Commissioner
Yeah.
Fair,
to
or Vice.
accept the closing flag?
Yep.
Yeah, probably.
I would draw my motion.
All right, motion is withdrawn.
Okay. Is there a new motion?
I'll make a motion to issue civil penalty for violation of reasonable skill and care. And we can drop that other one for making a false statement or knowingly making a false statement.
There was also an aspect of a,
And the 3-hour,
The 3-hour
leave the
course.
3-hour core course in there.
okay.
Leave the course in there. Mm-hmm.
So Commissioner Torbett's, let me get a motion in a second.
Yeah.
So Commissioner Torbett's motion is to assess a $1,000 civil penalty for failure to exercise reasonable skill and care, and to require this respondent to take a 3-hour course in ethics within 180 days and above and beyond the required continuing education. That's the motion. That was seconded. Commissioner Smith, you seconded it?
I did.
And it was seconded by Commissioner Smith.
discuss?
I mean, they still have the option to refuse, and then
Yeah.
we'll be right back here. But
Right.
which is what I can see happening. But I don't like the, okay, we've given you all these civil penalties and now we're just saying nothing. So
Yeah.
try again and see what happens.
I agree. I think I just would want to make the distinction that the $1,000 penalty is for the misrepresentation and the comments about the complainant on a public listing site. I'm taking into consideration what the respondent shared, that they were unable to show the property when they wanted to. They were unable to get access to take photos. And so I don't have as much question about the respondent's lack of skill and care with the sale of the property as much as I do, how are you talking about this individual in a public forum?
Yeah.
Like we just talked about,
Yeah.
like we just talked
Yeah.
about earlier.
So the friendly amendment to the motion would be to instead assess the $1,000 civil penalty for 6213-312B1, which is material misrepresentations.
Correct.
But I see, that's what I'm afraid that they're objecting to, is they're going to say it's not a misrepresentation, that it's an actual representation of what happened. That's why I would lead more towards reasonable skill and care. It's so, okay, maybe it is an accurate representation, but you keep that to yourself.
Right. Yeah, what does it state exactly?
I don't see how this is not Groundhog Day. We've already done this once, haven't we?
Yeah.
I mean, we've done this exact thing before.
Mm-hmm.
And it didn't work.
Maybe
Because
they
the-
just object to part of
No,
those
the complainant,
penalties.
they tried to move to a case and the complainant dropped it.
Yeah, I
But
think
the
we're just,
complainant hasn't
Complainant,
withdrawn
yeah.
their complaint.
Yeah.
They just are refusing to participate in litigation. They haven't withdrawn their complaint.
I think there might be some, some responsibility on the complainant also in this case, because they were difficult to do any business with. They want to keep the leads that were the procuring cause by the respondent, and that's why they got angry. They had the respondent withdraw the listing, but they want to keep working the leads they already have. So they're just cutting them out. I mean, it's just he said, she said here. I say close and flag. And
Yeah, I'm based on what you just said, Steve, and Joe. Yeah, I'd go back to my original motion and apologize for.
There's a motion on the floor.
Well, I'm getting there. I was just gonna say I apologize to everybody having to waste 5 minutes of your time here. Yeah.
So I can withdraw my motion. I just don't like how this is playing out. We came to the decision to have these civil penalties after discussion,
What about
and we are
a
gonna
letter
just,
of warning?
I think they've already got that.
Then that stays on the record.
It goes in their
that stays on the
file.
record.
They
What
don't
about-
have to agree to it.
What about a letter of warning in a class?
No. If they have to agree to something, it has to be a consent order.
Okay. All
So we
right.
could send a very strongly worded letter of warning.
Can I
Withdraw?
amend my motion, or would I have to tell you withdraw? I'll withdraw my motion.
So motion has been withdrawn.
Okay, I'll make a new motion.
Commissioner Torvik.
My new motion is a very strongly worded letter of warning. Can it still be closed and flagged after that, or no? The letter of warning is basically a flag. Yes?
Yeah, it's
Okay.
a flag.
Okay.
So do you want the letter of warning to discuss all the violations from our original finding?
I trust that Anna can write a strongly worded letter of warning.
Oh, no.
No,
No, Ariel writing that. Just want to clarify that.
I trust that
But we
Ariel can write
we
a strongly worded,
We'll
just
just include it.
convey our concerns.
So, if I may say, Commissioner Torbert's new motion is to send a letter of warning to this licensee discussing the violations of 6213-312B1 and 6212-403-1. Is there a second?
Second.
Seconded by Commissioner Smith. Has everybody said what they wanted to say? DJ?
And another thing. I'm kidding. Call the question.
Question has been called. That's non-debatable. Let's go ahead and vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? No. Hearing, we have 7 aye, 1 no. Commissioner, 2 noes. 2 noes, Commissioners Bagley and Gwen voting no. I'm sorry, Commissioner Gahn voting no.
Is that Commissioner Begley and Gahn are no's?
Yes.
Okay, thank you.
You still can't.
So the next item on the agenda is commission discussion or new business. Is there anything to discuss or any new business?
The next commission meeting will be February 11th, 2025. And for those here for CE, please make sure you sign out so we are able to grant your continuing education for participating in the meeting today. And thank you so much for coming and earning 8 hours of CE in less than 8 hours.
All right. With that objection, we are adjourned until February. Thank you all, commissioners.